Hello everyone and welcome back to Exam Ignite YouTube channel. This is module 4 part 2 video of the research methodology and IPR subject. This video will be covering the trademarks part of the module 4. Starting with the trademarks, this is an important question. You need to know the correct types of registration trademark in India and the categories of trademark, classification of trademark and the trademark registry, then process of trademark registration. So this was some of the main important questions that you should not skip. I'll be explaining everything from the eligibility criteria till the famous case laws, but in from among these are the some of the repeated questions that you can expect in the exam. So let's get started. Trademark basically it is a unique symbol used to identify the and differentiate the goods or services of one organization from the another. So this word itself says it's a mark or sign that design or phrase or symbol that or combination of these. So a trademark is anything that is identified as a brand to common consumer. Eligibility criteria for a trademark registration. So firstly, there should be something uniqueness and capable of identifying the source of goods or services. It must clearly distinguish the brand in the target market. Then it should not describe the goods or services. It should not generally, it is not protected. So the descriptive marks. So these words may be registered if they require second meaning. For example, Apple for the electronic gadgets. Similarity to prior mark. So the mark must be unique and it should not be similar to any existing registered mark. Who can apply then? Any proprietor or a trademark can apply for the registration. It is filed individually or jointly. Organization or associations can apply for the collective marks and this can be used by the members of the organization. Example, you can say Reliance symbol used across the products under the same organization. Next is acts and laws governing the trademark in India. Under the Trademark Act 1999, trademark producers are governed by the Trademark Rules 2002. The acts and the rules have been amended from time to time. Latest amendment is 2010, that is Trademark Act, 2017 Trademark Rules. Administrative authority. Here, trademark administration is handled by the Office of CGDPDTM, Government of India, where they govern the trademark completely. And the designation of this trademark symbols, this is used to indicate the ownership and status of the mark, commonly used as TM. This is for the unregistered trademark, SM for the unregistered service mark, R with a circle for the registered trademark, and the use of R without registration is legally not permitted. Classification of trademark. This is an important question asked in the December-Jan 2024. Goods and services are classified under the NICE Agreement 1957. Here, the classification is administered by the WIPO, used by 149 countries, African Intellectual Property Organization, African Regional IP Organization, European Union Trademark Office. So number of classes here is 45, 34 classes for goods and 11 classes for services. Example of the trademark class. Let us see class 1, where chemicals used in the industry, science, photography, agriculture, horticulture, forestry, etc. Then unprocessed plastics or resins, fire extinguishing preparations, fertilizers, compost, adhesives, biological preparations, these all under the class 1. Class 45, the legal services, security services, personal and social services to meet the individual needs. Then winner codification. This is the established in the Vienna agreement where it classifies the figurative elements of the trademark. Again, this is classification structure is categories are 1 to 29 and division is 1 to 19, section is 1 to 30. Example, you can say the little girl eating. Here the category is 2 human beings and division is 5 children. Main section is 3, that is girls, and the auxiliary section is 19 children eating. So the code is 25318. Next is registration of the trademark is not compulsory. It is completely optional. It provides a significant legal and commercial advantages. What are the advantages? We get a legal protection that it prevents from the unauthorized use. And exclusive rights, only owners get that. And a brand recognition, a logo and a brand identity help you to build a goodwill. Strong brands attract the new customers. Then asset creation, it is an intangible asset. Unregistered trademarks, no legal action can be taken for this infringement of an unregistered trademark. It is known as common law trademarks. So protection is possible through the passing of action. The owner must approve the goodwill reputation associated with the goods or services. Validity of the trademark. In India, the registered trademark is valid for 10 years and it should be renewed every 10 years. Indian Trademark Act renewal must be filed in the form TMR and it should be filed within the 1 year before the expiry. Types of trademarks registration in India. This is also an important part. A trademark may be a word that is used to say, speak, spell, or remember. It is recommended to choose an invented words, created works, unique geographical names. One should avoid the common geographical names or the common personal names. So, praising or descriptive words such as best, perfect, super, etc. must be avoided. A market survey should be conducted to ensure that no similar mark already exists in the market. Examples is person or surname of the applicant or procedure. Here you can say Bajaj. It is named after the Mr. Janmalal Bajaj. Then unrelated word having no connection with the product or service like India Gate for the food grain. Letter or numericals or their combinations like Yahoo derived from the yet another hierarchical officious oracle. So some of the distinct name you can observe like this type of mark they have used distinctive general word Apple, IT company, then Kodak, Ford, or automotive, or Udar, it is a financial technology, 4711, it is a perfume, alligator, network manufacturing, drink it to believe it for the soft drink slogan. Then trademark registry in India. So it is carried out by the five cities Delhi, Mumbai, Ahmedabad, Kolkata, and Chennai. So each office has jurisdictions over the specific states. Business must apply through the trademark office assigned to their state. So the foreign applicants, jurisdiction depends on the location of the agent. Next comes, you can see the territorial jurisdiction of the trademark registration office under where are the office location and what states come under that location. Process of trademark registration. Firstly, this is important. This is asked in model question paper 1 also, 2 also. Prior auth of such. So before filling the form, you must verify whether the intended trademark already exists. Do the market analysis. Then ensure it is distinctive. That is, there is no similar to existing registered market and yours is a unique one. So commonly used portals for checking that are given here. Then filing of trademark application, that is TMA. After successful prior art of search, the application should be filed form TMA. So application it is can be filled by the proprietor himself or through a trademark registration certified trademark agent. So filed at the trademark office having the jurisdiction over an applicant. Next comes the receipt or data entry and digitalization. Here applicant is received at the application is received at the branch office, data entry and digitalization are carried out, and applicant number is allotted within a few days. So the status can be tracked in the online using that application number only. Examination of the application. So it is examined by the trademark examiner. He checks the distinctiveness, that is uniqueness, then descriptiveness, how you have described it, similarity with the prior marks. Is there anything already repeated? Examination report, if there is no objection, it will proceed. If there is an objection, then the applicant must respond. Reply to the objection. So applicant submits a written response to the objection. If the examiner is satisfied, he will move it forward. Not satisfied, then he will refuse. So applicant can change the rejection before the IP division. Publication in trademark journal. If accepted, the application is published in the official trademark journal. So publication allows the public to inspect the proposed mark. So opposition state is 90 days. So after publication, any person may oppose the registration within the 90 days. No opposition filed, then it will proceed. If it is filed, then the opposition proceedings are conducted. What is this opposition proceeding? Both the parties are given the opportunity of hearing. So opposition is decided in favor of the applicant, then registration is allowed. If it is accepted, then the application is refused. Grant of the trademark registration. If no objection is filed, then the opposition is decided in favor of the applicant, then he will get the trademark registration certificate and it becomes a registered trademark. So main points you have to remember here is the English translation must be provided for the non-English words in the trademark. If you are having any regional language in the trademark that you are giving, then the translation must be given. For the priority claim, details required are early application number, filing date, country, goods, like that. As per the Delhi High Court notification, IPAB is abolished and dedicated IP division handles the IPR dispute. So you have to write this flowchart because they will mention the flowchart. So this is the receipt of the applications, data entry and the digitalization at the branch office, as I said. Then examination of the applicant's approval by the supervisors and release of the examination report. If there is any objection, then objections response by the applicant and supervisor satisfied with the response. If not satisfied with the response, then it is rejected. If satisfied supervisor with the response, then the publication of the trademark journal. So again, in case of opposition, that is opposition proceeding is done. If it is accepted, then it is refused. If it is not accepted, then no opposition. If there is no opposition, then the opposition decided in favor of the applicant and trademark is registered. If your application is rejected, you can appeal may be made to the IPAB also. If the decision of IPAB is in favor of the applicant, the procedure is followed for the registration of trademark again as per the notification, as I said it just above. Then comes the important facts about the trademark. Correction in the trademark application or registrator. Corrections are allowed and also must not significantly alter the identity. A small changes can be made. Removal of the registered trademark. It can be removed if the registered without the bona fide intention to use. It is not used continuously for 5 years from the registration. It is not used for 3 months prior to filing the removal application. If the trademark was wrongly registered or continued in the registered by mistake, then the registrator has the power to remove a trademark on own motion. So sound or smell has a trademark. Yes, sound or smell can be registered as a trademark. Condition, it must be distinctive, must be graphically representable, and using a chemical formula. Sounds marks must be recorded in MP3 format, depicted graphically. Rights against the similar or identical marks, so cannot always restrain a third party. He has used the mark earlier or same goods or services again. So Protection Act is section 28 and sections 27, 28 for remedies for registered trademark, 27 for protection of unregistered trademark. Passing of common law remedy available to both registered and unregistered. Infringement suit only for the registered one. Seeking trademark protection in foreign countries. So national, we are having two options. One is national filing. Here, file application is directly sent to the trademark office of the foreign country. Then Madrid system, WIPO, where single application protection in multiple countries. Priority must be gained within the 6 months of the first filing. Single free payment and countries must be the members of Madrid Protocol. Trademark statistics. So 90% of the trademarks is filed. Increase is observed. 65% in the trademark examined and 154% the trademark registration. So highest trademark examinations were done in 2016-17 and 5 lakh plus application. Highest TM of registrations, trademark registrations were done in 2018-19, around 3 lakh plus registrations. So international treaties and agreements for trademarks. So these are administered by the WIPO and the famous trademark case keynote. So Coca-Cola Company versus the Bisleri International Private Limited, that is Mazda case. Here, the Bisleri told the Mazda trademark rights in India that it is having to Coca-Cola. Bisleri later applied for the Mazda trademark in Turkey. So they started exporting Mazda to that country. Then Coca-Cola filed a suit, that is, there is an infringement passing off. So the court finally decision that gave here is Bisleri restrained from using the Maza in India for export, and the export using the trademark held as infringement. So it said to stop doing that. So this was all about the module 4 part 2. This completes the module 4 of the RMI subject. I hope you are clear with it. Thank you for watching. Please do like, share and subscribe to Exam Ignite for the further videos. See you in the next video.